Good morning. It is February 6th at Senate Judiciary. We are taking back up on S12, and we have Brenda Gooley from DCF to provide some testimony. So floor is yours, and thanks for being.
Good morning. Thank you. As you said, I'm Brenda Gooley. I'm the Director of Operations for the Family Services Division of the Department for Children and Families. And I wanted to provide testimony this morning that outlines the role of the Family Services Division of DCF when we are conducting child abuse or neglect, child safety investigations, and specifically to outline how that work interfaces with the work of law enforcement. So I'll begin just by pointing out that there is a set of statutes that govern the work of the Child Protection Agency that are separate and apart from the statutes that govern criminal activity. Vermont Family Services Division is the state of Vermont's one and only statutory child protection agency. We have a hotline, centralized intake, and emergency services, where calls of concern come into that hotline and then get reviewed for consideration of whether or not they meet criteria for allegations of child abuse or neglect. If those allegations are accepted, then a family services worker is assigned to then conduct that investigation by interviewing the alleged victim, the alleged perpetrators, and other individuals. At times, there is information that is both an allegation of child abuse or neglect and an allegation of criminal activity. In those circumstances, the statutes that govern child protection and the statutes that govern criminal acts both kick in at the same time. And so there's additional statute that speaks to the role of the Child Protection Agency and law enforcement in doing joint investigations during those circumstances. If there's a criminal allegation, generally speaking, law enforcement has the lead and the family services staff are present for those interviews. How that might play out is a law enforcement officer and a family services worker would be in the same room together with an alleged victim and with a perpetrator for those interviews. Those materials may then go on to become materials that lead to a criminal conviction, or they may not. Those materials also will go on to become information that is used to make a determination of whether or not child abuse or neglect has occurred, and to inform the decision as to whether or not that individual should be placed on the child protection registry. There's also statute that is clear that throughout the state of Vermont, in each of our counties, there are special investigation units, which are multidisciplinary teams that consist of law enforcement and family services division staff that are required to work in collaboration in these circumstances. Specifically, we ensure that we intervene in a way where the victim only needs to be interviewed once, so as to minimize trauma to the victim. We ensure that the information that is being shared, law enforcement has the lead so that we're not interfering with any criminal investigation. At the same time, we ensure that the Child Protection Agency has the information that we need in order to address any child safety concerns that exist. I think it's also important to point out in these circumstances that the criminal burden of proof for action in a criminal court situation is different from the burden of proof specific to a child protection situation. So within Family Services Division for child protection, we look for the burden of proof that is a preponderance of the evidence. And that burden of proof is a lower burden of proof because our purpose and our function is to ensure child safety. So in summary, I point all of this out as a way to say we wanted to be clear that the information that is gathered by the Family Services Division in the context of a child safety investigation, even if it is in collaboration with law enforcement, that those records are DCF records. They are the records that are necessary to gather for child safety purposes and need to be referenced throughout any consideration of child safety, and therefore are DCF records. And that includes law enforcement summary of interviews. It includes calls of concern to our hotline. It includes summary notes specific to the interviews that have occurred. And it includes law enforcement affidavits. That those are DCF records. So I'll pause there. That's really, I would say, the heart of what I wanted to be able to testify to here this morning, and see if there are any questions. And also want to reference, I do have colleagues that are participating virtually in this morning's hearing as well that may have additional information to add. Thank you.
So I guess my first question is, regarding current practice, the records that you do get now, what happens to them? I'm not quite sure I understand what's being requested.
What's being requested is really that we are able to carry on as we do with the clear understanding that our records are our records, even though information is gathered side by side with law enforcement. So for example, a call of concern, about 13% of the calls of concern to the child protection hotline are made by law enforcement. We receive those calls and enter them into our family services database as what we call intakes. So those intakes, 13% of them are from law enforcement. And yet those are DCF records, right? It's the DCF intake form is the call of concern that's been received. And then a family services worker will conduct that child safety investigation, and they will write up a summary of each of those interviews that occur, and they will make a determination. And that will also be a summary that is entered into our database, which is Family Services Division FSD.net. So that information, we want to be clear, is DCF records, even if it is information from or that was obtained in collaboration with law enforcement.
So what in this bill would change what you're currently doing as practice?
So we have a memo that we have submitted here today that has a line that we're recommending be added to the bill, just so that we're being clear. What we would like is to make sure that there's not circumstances in the future where someone says, oh, for example, now that this is sealed, DCF can no longer use or reference a law enforcement affidavit, for example.
Does DCF currently have access to sealed records?
So DCF currently has access to the law enforcement affidavit and all of the other information that was gathered in the context of that child safety intervention. And we do not consider that to be separate law enforcement records. We consider that to be our DCF records.
Okay. Senator Brute?
So if I'm, this is, to cut to the chase, this is reassuring for me, because in earlier iterations of the bill, I had thought what the administration was seeking was the ability for DCF to go into sealed records, whether or not they had a connection to a person. In other words, what you're talking about here, as I understand it, is in the course of an investigation of child abuse or related activity, you're developing records alongside law enforcement. And then what you're worried about is that in the event of an expungement or a sealing, you would lose access to your own version of that record.
Correct.
So I'll just check with Michelle. I don't think it would qualify for sealing if the offense that we're talking about sealing is related to child safety and welfare. Is that correct, Michelle?
You mean the types of offenses that are eligible?
Yeah.
You know, arguably, could there be something? I mean, cruelty to children, sex offenses, all of those things are excluded from eligibility. Whether, I don't know, it would probably be for the department to say whether there's anything on that list that would concern them in terms of child protection or their records. But I think I get what the department is asking for there. And I think, you know, they've got some suggestive language there. So I think it's just a policy decision for you around, do you want to leave that open so that they can have access for child protection purposes under chapter 49, and just say you can use them for those statutory purposes, and it might include something that was sealed. But I think in general, it's not gonna have things that
Right.
would necessarily relate, but I don't know all the things that you necessarily look for.
Right, so we have many different categories of child abuse or neglect.
Yep.
Physical abuse, sexual abuse.
And none of
neglect,
those are
domestic harm.
eligible.
And so it certainly could be that we are investigating in collaboration with law enforcement in any one of those circumstances, and therefore in our child safety investigation, those materials would be in there.
But
Right.
to my point, I think what we're saying is in the vast majority, if not all cases, it wouldn't be eligible for sealing anyway. But let's assume that there was an overlap that had been, you know, unforeseen. I wouldn't have any problem with this language, because to your basic point, you exist to protect child safety and lean in that direction, preponderance of the evidence, as opposed to, beyond a reasonable doubt or some other higher standard. So this is reassuring to me, because it seems to me to be a belt and suspenders that probably isn't going to come into play anyway. What I had thought the administration wanted was a broad ability for DCF to be exempt from the sealing piece, or rather to be empowered in all cases to look at sealed records if they so chose. But that's not what you're seeking.
Right, that's not what we're seeking. We are seeking the understanding. We are seeking that all have the same understanding as we do, that information that is gathered in the course of a Family Services Division child safety investigation that included law enforcement. It is our records.
And then my last question, your records are confidential.
Correct.
Yeah, so we don't have the worry that DCF is going to have a record and then somehow it will prevent someone from getting a job or a professional license, or the other issues that we're talking about. Or is that?
So there is, in the state of Vermont, we do have a child protection registry. And for employment purposes, if an employer is an employer of someone who is working with vulnerable persons, which could be the elderly, could be, a job working with children, such as in a school system or a childcare. When that individual applies for a job, typically their employer will ask for them to sign a release giving permission for the child protection registry to be checked. If that individual, if their name is on the child protection registry, that would mean that they are an individual in the state of Vermont who has been substantiated for an act of child abuse or neglect. So in that circumstance, it could impact employment purposes, specifically if it's employment with vulnerable persons, only if that individual gave permission for that check to occur.
Yeah, which personally I wouldn't have a problem with. I think we're balancing interests, and we are balancing the interests of someone who was found guilty of an offense. We're just saying that after a certain period of time, that should be sealed and they should be allowed to go through this. That doesn't mean that we need to allow access to a vulnerable population without a check. So,
And along with the registry, these records could also be produced in litigation if there was a discovery request.
Yes.
We provide some examples or situations where that would happen.
So if there were a court order for DCF records, then DCF would be required to provide those records.
So I got a question, I don't know how to phrase it. A long time ago, in my other committee in the afternoon, DCF came in and I believe the subject matter was we were discussing birth certificate records after the age of 18. Those individuals having access to their records along with finding out who their parents are, whatever else. And the same point came up where DCF records are DCF records, okay? And without legislative direction, DCF was not willing to release any investigations or whatever else that DCF was involved in. So my question, I understand what you want to simply protect the records that you have. But my question is, so are any of these records susceptible to any FOIA request?
Any what request?
FOIA request, the Freedom of Information Act.
Oh, I don't know.
If they're your records, I mean, then they've been sealed over here, but there's still a loophole over here. I'm just wondering if they're available for FOIA request. Did you only have that?
I believe, so I'll answer your question generally, and then I don't know if our general counsel, Jennifer Michael, might want to provide additional testimony. I think what I would say is we do have a records request protocol that we follow where we are clear that our records are confidential. And so that those records requests need to go through a level of review where we are clear that we're not releasing confidential information.
So that's nice, but maybe Jennifer can answer. Are they susceptible to a FOIA request?
Yes, Senator Jennifer Micah, General Counsel for DCF. So that law that passed last year, we got very clear direction from the Senate that you wanted very open records and that you wanted as much information released as possible. And so we are still working through a lot of the details of those. I know it's frustrating for some people, but we are getting to the conclusion on what we can release and what we can't. Most records in those files will be released. They are released specifically to the youth who was the subject of the records. And so if there are records in there about, for instance, a parent, that parent is not the subject of the record, so those would not be provided. But we do provide a lot of records, and there might be some references to some activity. I also want to note that we do not often get notice that a record has been sealed. So what we have in our records is the information we have gathered and that we have been given by the courts when it's relevant to us. But information about sealing does not often get to us. But I will say, if it's about an adult in the child's life, then no, that information would not be released.
Just to summarize what I think I understand it now is that your current practice allows you to use sealed records when determining whether or not someone is going to go on the registry, and you are asking for clarification in the statute just to establish that you can continue that practice, right?
Correct.
And with the eligibility, and with the idea that eligibility wouldn't include this suite of things that we're talking about, I don't think, child abuse, sexual abuse, etc. I don't think it would be an issue. And since it's just continuing their current practice, and it's not going to apply to people who aren't part of DCF records already, it doesn't seem to me be a real issue, but that's a surprise because all last year, I think it was last year, not the year before, when we talked about DCF, it seemed to me that people talked about it on the administrative side as though seeking broad-based access to sealed records. You're just wanting to have your records remain as they are, which are already confidential.
Correct.
Okay. Any other questions? Archie, did you have further testimony?
No, I do not. I don't know. If,
I know, but it does look like there's some colleagues who also wants to testify.
Okay.
Great. So I think next we have Catherine Ward on the list.
Hi, good morning.
Good
Am I
morning.
on here with my video? There we go. I'm sorry. Yeah, I'm Catherine Clark. I'm the director of the Commissioners Registry Review Unit here in DCF. I don't know that you need to hear from me. I was here really just to answer if you had any questions about how these sealed records might come into play when we are reviewing substantiation determinations. But I don't have anything further that I would need to add.
That's good. And Jennifer, Micah, I know you were kind of part of the discussion earlier, and so I'm getting a sense we're just kind of all bouncing back into having a discussion, which is totally fine. But did you have any additional testimony, or?
I guess I just want to be I want to make sure that you understand that we're talking about using the information for expungements as well. And this may be why there was some confusion last year. We're not asking for anything different this year than we were last year. But what happens is, and why there's the question of our records when we're doing the investigation. And then when somebody's name is placed on the registry, they stay on for a certain number of years, and then they have a chance to come off the registry. During that period of time, their criminal records may have been sealed, and we still have access to our records. So I just want to make sure that the committee understands that is what we're doing. We are accessing those records for that purpose, but all our access is for our internal processes related to our investigations at the beginning, and later for the expungements and substantiations.
Sure.
Yeah.
Just a quick question, Jennifer, and maybe a foolish question, but it will clarify things for me. So if someone has not been involved with DCF, they're not a part of your records, and they're not on the registry or any involvement like that, and their records are sealed, you are not seeking access to their record.
No, not at all.
Okay, thank you.
And the law has, and we're not seeking juvenile records either. We do that through the court process, because that Chapter 51 has the process where you seek court records through a court order. And if we feel we need those records, we do it through that process. For instance, at the Human Service Board at an expungement hearing, it's not very often, because there aren't very many children who are involved in our registry, but we're not seeking those either.
Thank you. Any further testimony? Any further questions? Ready? So I don't see Susanna, so we can see that Stuart and John are on the Zoom, and so we can take their testimony. I have a feeling it seems kind of in line with what's happening with DCF.
I just want to say, so Susanna's upstairs in House District, but if Kayla, you want to maybe email Nate and just, because you guys are going quickly, do you
Yeah,
want
I think,
to do that just? in
yeah, that
case?
works, and then we can have their testimony.
I think she's one of the first witnesses.
I see Laura Carter is here. I don't know if Laura is here for Susanna or, but
So I was just gonna say, we are here together, because I've been following this bill very closely, and I followed H 655 last year, which I know became Act 174. Susanna is supposed to be here, so I don't want to like kind of dive in without her. So Stuart, if you are good, you can start. I messaged her as well. So.
thanks. Yeah, Senator, we're prepared to go forward, and I think it's probably appropriate to be on the direct heels of DCF in light of the similarities of our systems. So just for the record, my name is Stuart Scher. I'm the General Counsel at the Department of Disabilities, Aging, and Independent Living, also known as DALE. And with me is John Gordon, who can introduce himself. Go ahead, John.
John Gordon. I'm the Director of Adult Protective Services within DALE.
Great. So thank you for the opportunity to speak to this issue. I think you heard, in addition to DCF's position, you heard Dale's position. There are a lot of similarities between the DCF child investigation process and the adult abuse or maltreatment investigation process that's conducted by Dale and Adult Protective Services. The statute, in fact, was recently amended to better align both of those processes. So I would say that, much like you heard from DCF, we are not looking to change current practice, but rather to continue it. As you heard from Brenda, oftentimes APS and law enforcement are engaged in joint investigations, and there is, in fact, statutory authority for those joint investigations in Chapter 69 of Title 33. In addition to what DCF does, which is investigating allegations of child abuse and neglect, Adult Protective Services investigates allegations of adult abuse, neglect, and financial exploitation. So there are perhaps opportunities for records in the possession of law enforcement that may be related to financial crimes that would be of additional interest to APS. And so much like you heard from DCF, we'd simply be looking to ensure that the records that APS gathers in connection with a joint investigation become the department's records so that we can use them in pursuing our own investigations, again, under a preponderance of the evidence standard, and could use them also in an expungement proceeding. So there is really no difference between the intended use. It's a continuation of existing practice. It's quite possible that many of the crimes that would be part of law enforcement's investigation would not be subject to sealing. So it may be a non-issue, but again, this is to Senator Baruth's point. But I think that it's really just a continuation of our existing practice that we'd be looking for. And so the language that we were proposing does fairly closely track the language that DCF has proposed. I don't know if that was included with any submission this morning. I know that we had talked about including them together, but if you don't have that, I'm certainly happy to.
We do have it.
Okay. So that is the primary point that I wanted to make. There was one other issue, if you'll indulge me. There is some language in the APS statute in section 6914A, which specifically gives the commissioner of Dale the right to obtain from VCIC the record of convictions to the extent it's necessary to protect vulnerable adults. And so we believe that this is a clear recognition on the part of the legislature that the protection of vulnerable adults is paramount. And we would argue that this is an example of where the rights of those vulnerable adults, if we're conducting a balancing test, it really does need to outweigh the rights of a criminal defendant to wipe the slate clean and get a fresh start. We appreciate that right, that desire exists. And such a record could be used to deny a request to expunge one's name from the registry. However, a denial of a registry expungement doesn't deny an individual all employment opportunities. It only would deny them the opportunity to work with vulnerable populations, and only if their request for a variance from that conviction were denied by the department. So we would ask that there be an exemption for our current practice, which is to get those records with a recognition that vulnerable populations need to be treated differently than those of the general population, that they need to be protected. And when an individual wants to apply for work with a vulnerable population, it's important that their criminal history be available to the department to review. But it doesn't mean, again, that they're going to be denied employment. They may be denied employment with a vulnerable population, But that's only, again, if they're denied a request for a variance from that conviction by the department to continue to work with a vulnerable population.
So just to clarify, are you saying that the department can't currently access those records when it comes to doing employment checks?
If they're sealed, we wouldn't be able to see them, but we do have access to that information now. We have arrangements with VCIC, we have statutory authority to get that information. But if a record is sealed, we would have, as Jennifer indicated, we don't get notice of that. We wouldn't know. And so if that record's sealed, we would never be able to look and be aware of a conviction that occurred, let's say, as little as 3 years later. But there are certain property crimes that would be subject to sealing under this bill that would be quite relevant to whether an individual should be working in a long-term care facility, should be working as an independent direct support provider or direct care worker through a designated agency with vulnerable populations and have access to their funds, for example. Maybe they have a petty theft within 3 years. Is that relevant to whether they should work with vulnerable populations? Perhaps. Maybe it's not. Maybe a variance request would recognize that the conviction was not particularly related to the type of work they're trying to do, or was too old. But those are factors that could be considered in connection with a variance request. But we do have concerns that if a record is sealed and the department doesn't have knowledge of that or access to that information, vulnerable adults could be subject to greater risk of harm.
Got it. So just to confirm, you currently cannot access sealed records when going through the employment process, and you're asking to now have access to sealed records for the employment process?
Yes. We have access to records that are available yes, there's nothing in the statute that allows us access to anything that would be sealed. But we would be asking for a continuation of access to all criminal records in order to make sure that vulnerable adults could be adequately protected.
Any questions?
I got a quick one. Hi, Stuart, how you doing?
Good. How are you, Senator?
I haven't seen you in a year, and I see you twice within the same week here, it appears.
Right. That's right.
How often, can you give us an example of how often that actually occurs?
Which aspect?
As far as looking into VCIC records, is that on every employment application?
Yes, it's actually anytime an individual is working with a vulnerable population or is to be paid with funds administered by the department. We have a background check policy that requires those employment arrangements to be subject to our background check policy, which includes a criminal background check, an adult and child abuse registry check, and a federal exclusionary database. So we do tens of thousands of background checks a year.
All right, thank you.
But again, individuals who are seeking employment would have to give an authorization for their prospective employer to see their background check information. So that is sort of a safeguard measure there. But we do conduct quite a number of background checks for employment purposes.
Additional questions? Stuart, did you have any additional testimony?
No, that's all I have. And I don't know if, John, you wanted to say anything, clarify anything I misstated, or you're all set. It's up to you.
John Gordon, Director of APS. I don't have a whole lot more to say. I think it wasn't clear to me whether how APS records would be treated under this bill. And the primary concern that I had is the possibility that information that we would obtain during the course of investigation may then be entangled in a sealing process, and we wouldn't be able to use it for our own proceedings or from any subsequent expungement proceedings. So it's very much in line with what DCF is asking for. We're not looking for a broad-based authority. It's more of if we gather something and then it is then sealed, what is that? What are the implications for that in the future use on information that we've previously gathered as part of one of our cases?
Thank you. I know that we're missing 2 committee members right now, so I don't know that I want to make the decision at the moment regarding what we keep or what we don't keep. But do either of you have any thoughts initially?
I don't. Just of my understanding, I don't think we intend to change anything. It's already an existing statute. It's a matter of addressing any additional requests for carve outs, is I believe what our mission is on.
Yeah, I would agree with that. I mean, I think that the 2 proposals regarding the language recommendations for what is in current practice and, getting these records and joint investigations and then having those records and being able to continue using them as they are currently, I think that makes sense. The additional request for carve-outs for employment purposes, I'm not too keen on that at the moment. I mean, we are going to get some testimony from the crime research group. I think the week of the 17th about desistance, the idea of 10 to 15 years later is somebody who, wrote bad checks 10 or 15 years later, are they going to, and if they haven't done anything else in that time frame, how likely are they to reoffend? And it seems like the data shows that they're just as likely to offend as somebody who's never been convicted of an offense in the first place. So that's some information that we can use later on to help. But yeah, that's my initial position.
Senator, if I may, I just wanted to reiterate that there is that variance process that we have built in. So there's a recognition that the age of a conviction is one of the factors that's taken into account when a prospective employee is denied employment with a vulnerable population. There is an entire process by which they can ask for a variance from the agency that would be employing them or from the department to consider the age, the seriousness of that offense, their willingness to accept culpability for that, and so forth. And that all gets built in to the process. So I certainly appreciate the fact that we wouldn't want to be looking at a conviction for bad checks or petty thefts 15 years later and placing as much emphasis on that conviction as we would something that happened in a year or two prior. But I think that's sort of one of the things that we certainly are directing individuals under our background check policy to consider when analyzing a variance request.
So I guess in response, I mean, what offenses wouldn't you be able to see that are, I'm not understanding the timeline where you're getting 1 or 2 years prior.
Well, a misdemeanor would be subject to sealing as early as 3 years after, is my understanding. So if there were something that had happened 3 years prior, or 4 years prior, a misdemeanor could be relevant still. Bad check conviction, misdemeanor, a petty theft misdemeanor. These could be relevant to working with populations if it means having access to their finances. And so those are things that we would want to take into account, even if they happened 3 or 4 years prior, and would be subject to sealing.
So, and I just want to make sure I'm fully understanding the current.
Sure.
So this is a little complex, but so for example, petty larceny is currently a sealable offense and is a misdemeanor, and you don't have access to that currently for employment.
I would think not.
Maybe anything else?
Yeah, I guess I'm just a little confused too. So it's not allowable currently to see that on the background check, right? But under this provision that it's being requested, they would want to be able to have access to those types of.
So as I'm understanding it, there are 3 requests.
Yeah.
2 are on that piece of paper, and then the 3rd request is for access for the purposes of employment.
Yeah. Yep.
Yes, so yes, the point is we have access to criminal records. We frankly don't know what we don't know. We know that a check is conducted. I'm assuming that if something is sealed, and there's no express authority to allow VCIC to share that information, that is not being shared. But we don't know. We don't know when a record is sealed for an individual. But what we are asking for that information because it frankly could be relevant. We don't have access to it now.
Thank you. So, unless there's no further discussion or questions, I think we can put a pause on this for now and then revisit it when we have the rest of the committee. And in the meantime, we can take testimony from the Office of Racial Equity. Susanna.
Good morning.
Morning.
For the record, Susanna Davis, Executive Director of Racial Equity. Thank you for having us. I'm joined by a colleague, Laura Carter, who's also on the call. Laura is a member of our Division of Racial Justice Statistics and is our sort of in-house expert on records management. And so we are grateful to have her, and I may lean on her during today's testimony to help me cover anything that I've missed or misstated. Thank you for having us, and thank you for your flexibility on timing. We have a lot of thoughts. We had a lot of thoughts last session in other iterations of this conversation. And despite having had a year plus to think about this, you may notice that my remarks appear a little bit scattered because there's a lot to say and a lot to think about. And I know you all have heard testimony already from a number of people. And so I'm just going to address some of that. So stop me if it gets strange or confusing. All right. So first, I just wanted to say really clearly, the Office of Racial Equity supports retaining expungement as an option. We're deeply concerned with the idea that the state would say that there are offenses that we're willing to put away in a drawer somewhere and not look at or not permit others to look at, but we still want to keep them. And I hope I'm not being too casual here, but I'm reminded of the running joke about how millennials love to keep the box that their cell phones came in, even though you know you're never going to need it again. It kind of reminds me of that. If we're going to keep a record because we think we need it, then we need it. But if we're saying we kind of don't, then I think that as a matter of true access to justice, then it makes sense for us to retain expungement on the table as an option. One of the things that we noticed more broadly just in this conversation, not just in Vermont, but in jurisdictions around the country, we want to make sure that we're being really clear about the terms that we're using. So our office has had some conversations with people from other jurisdictions on the same topic. And what we've noted both in and outside of Vermont is that a lot of times people are using these terms interchangeably. So we want to be really clear about what it means to seal, what it means to expunge, what it means to retain or to log something. One of the things that we will recommend to the committee is that you invite the state archivist and the chief records officer to share with the committee about records management in Vermont, the applicability and the value of having a management strategy in place once the access period concludes. I also want to just note something. I think it was you, Chair Hashim, who, excuse me. I'm also one of the many people not feeling well this week, so I apologize. I think it might have been you, Chair Hashim, who mentioned the idea of giving people hard copies of their records as a matter of course. And that was something that we would strongly agree with. It's a recommendation similar to one that we made in a report we issued last year on access to carceral records of oneself. So just as a matter of practice, we see that as positive and would support something like that. I want to go back to what it means to be clear in our terms and in our language. As we're thinking about drafting statutory language and guidance in general for those who have access to these records, we just really want to underscore the importance of having clear and consistent and precise language, because if we choose to expand sealing eligibility or any other factors here, we want impacted individuals to have a clear and realistic understanding of what are the amendments to their criminal histories being made. And I think it would be really important to include plain language here. And when I say plain language, I mean that as a term of art. Depending on who you ask, what constitutes plain language is either up to an 8th grade reading level or as low as a 3rd grade reading level. Again, that'll depend on who you ask. But we have found that our colleagues in places like the Developmental Disabilities Council, for example, have been really good at helping us to understand what it means to provide plain language access to people, just to make sure that our statutes and rules are going to be really accessible to everybody who's going to be impacted. I think that as you all are talking about the issue of employment, and again, I'm kind of just going down a bulleted list of all the things that I know you've heard of that I want to make sure that I address. I know that the topic has come up about employment discrimination, and barriers to employment. And I think that one of the things that our office has really resonated with our office is something that comes from Elizabeth Westrop. She talks in a book that, in a journal entry in the Journal of Criminal Law and Criminology, and she talks about the goal of these laws being, and I'm going to quote her directly, a statute that explicitly bars employment discrimination based on criminal history records. And later on, she adds that adds a requirement that employers list disqualifying offenses up front and implement a time limit past which employers cannot consider old offenses. I think if we're talking about the issue of employment and the impact that records management is going to have on it, that's going to be something that could be really, really key. And we also think that that might help to add some dimension to the question about OPR's access. I know you all have already said that you're not, that you're going to put that to bed. But just in case that should resurface again, I do think that considering this kind of a goal would be helpful in determining whether that kind of access would be actually needed. All right, we're going to continue here. A couple of other things that we heard mentioned. We also agree with the Defender General's assessment that we do need some kind of protection, or at least a transition, for people who entered, for example, a deferred sentencing program under the reliance that they might end up becoming qualified, that they might end up qualifying for some kind of expungement. I think if we do end up changing what is on the table for them as options, we're going to need some kind of an off-ramp so that people who entered those programs in good faith don't feel like they've had the rug pulled out from under them. I think that's going to be really important for us to maintaining a sense of credibility, and again, in talking about access to justice. I'll remind the committee that the RDAP report from 2020 does indicate interest in expungement and sealing for adults and for juveniles. I think it would be worth further exploration. We know that is a deliberative group that needs to be able to take its time and wrestle with the issues it's presented with, but that when it does and when it's afforded that time, that it delivers a work product that I think is really valuable. So to the extent that you all are interested in hearing from the RDAP on this topic, I think that would be a good path for continued inquiry for that group. All right, continuing. Another item that has come up in our internal discussions as an office that we're concerned about is thinking about who externally, which entities will have access to the actual records is one thing. But it's, I think, important to remember that the judiciary still maintains a log of sealed and expunged records, pardon me. And so I'm not certain that you all have yet heard a lot of testimony on that fact, but I think it's going to be really important that we keep in mind that there is that log in existence. And so that may be an access point that if we haven't figured out how to deal with that, then we should. Because if we're talking about sealing or expunging things and there still maintains a separate log that does not have the same considerations applied to it, we may be undermining ourselves with that effort. And again, I'm not in the judiciary, so I may have limited understanding of what that log actually does or represents, but I think it'll probably be important just to check on that. I also, I know that at the top of my testimony, I said that we as an office support retaining expungement as an option. I want to come back to that. I think that, I know that Vermont likes to move forward, likes to be a leader nationally. And I do think that it's worth reiterating that we would be an outlier if we move to a single track system. Again, I mentioned our office has had conversations over the last year on this topic and doing some research of our own. We have a report that is unpublished. We didn't want to appear to be stepping on any other reports that were actually commissioned by the legislature. So we do have research on this that we would be very happy to share. We haven't published it yet, but we can. But in that research, we reached out to 7 jurisdictions and had substantive correspondence and back and forth conversations with 3 states in particular. Those are Pennsylvania, New York, and Michigan. We heard a lot that seems really promising, and a lot that's happening around the nation in what's referred to as this clean slate initiative. One of the things that we did hear consistently from all of those jurisdictions is having any partners or entities that had criminal history records or data on the same page and having them working together, particularly if their systems are disparate. And in Vermont, we have disparate systems. So I think that really coming and making sure that everybody understands what's expected of them, both from a looking at the spirit of the law, but also from a technical perspective, is going to be really, really important. Which leads me to another point about upgrading systems. I know you all have heard from a few different entities.
Real quick,
Yes,
Suzanne,
yes.
can you tell me what states did you mention earlier? I heard, was it New York and Pennsylvania?
New York, Pennsylvania, and Michigan were the 3 with which we had the deepest correspondence, but we had a total of 7 in our list of states we communicated with. And our understanding is that the working group that had been headed up by Judge Sone also had additional contacts with other jurisdictions, which mentioned, I think, California and Utah as well. So I think between all of the efforts of different people looking at this, we have a good spread of other jurisdictions who we've heard from.
Thanks.
I will, just as an aside, in some of the meetings that we had with the 3 that I mentioned that we reached out to, I want to communicate the nerdy enthusiasm with which we were met when we communicated with those jurisdictions. One thing that came across to me is that those who've undertaken Clean Slate Initiative are not only willing to discuss it, but are truly, it's as if they're spreading a gospel almost, in the sense that they've seen such positive gains from being able to provide this level of access to justice and being able to provide good expungement or at least stronger protections with sealing, that I think it's really worth learning from them and the experience that they've had in creating a system that's more expansive and more protective of people, not less so. Let's see, I will continue. I know that you've also been hearing a conversation about this concept of super sealing, about extending the time period during which things may be accessible. No, we're not with it. I don't see that as being fruitful. I think, again, if if we as a state have determined that certain things are ready to be put in a drawer, then it doesn't appear to make much of a meaningful difference whether we retain access for a decade or 2 decades. I think if we're going to have these records following people around throughout their lives, how long is long enough for that continued punishment? I mean, in a sense, it is a form of just having to continue to look over your shoulder, so to speak, and things being able to follow you around. We feel the same about things like access at roadside, and whether or not that's something that's actually going to be helpful in a law enforcement context. I think we have to ask ourselves, what's the purpose for which we would want to keep records for that long if we've already determined that those records are eligible to be not front and center anymore? Is that a cell phone box that we're keeping, in other words, without having to need it? I want to talk a little bit about the concept of petition list sealing. I know that there have been some discussions about petition lists or automatic sealing. And I think that for us, one of the biggest things we want to note for the committee is that they've got to take into consideration the disparate systems that we have that contain all those data, and the completeness and the quality of the data that are held in those systems. Because when we talk about automated processes, there's certain coding or algorithms that need to be able to run and to identify which records are eligible for sealing. And so if those automation processes are not scripted correctly, we could end up either missing records that would have been eligible or somehow otherwise fumbling the actual sealing process. So we've got to be able to have, and this is one of the things that we heard from those other jurisdictions we talked to as well, was who's going back and checking whether it's actually being done or being done correctly? Are there still records on the books that are not being swept in that automatic process? And how are we finding it out also? Is it the person about whom the record is has to come back and ask us to do a check, or do we know to do a check? So to the extent that anybody is thinking about petition lists or automating that process, that's going to be something we have to be really, really tight about. Somewhat related to that, I want to talk about the concept of digital punishment, and just remind the committee that even whether we do expungement, whether we do sealing, either or any combination of those, applying that to a criminal history record, it would represent our best effort at protecting people and allowing them to get a fresh start and to move on to new phases of their lives. But because we live in a digital age, information still likely exists online. And so in some senses, people may still be experiencing the long-term and residual effects of that, what's referred to as digital punishment, this idea that things are still going to live in perpetuity on the internet. And so to some extent, that's not fully in our hands. We don't control, for example, background check websites that allow people to pay for information. So that's not necessarily something that we can fully fix for people. But again, we want to think about what is accessible to the public and what kinds of consequences are we trying to avoid that people still may be experiencing if we're not providing those ancillary protections. And that's one of the reasons that we make the recommendation about, for example, having that list of disqualifying offenses up front if we choose to allow employers to have certain disqualifying offenses that allow them to discriminate against people in hiring. Those are some of the things that we think about, that we may offer certain kinds of protections. Are those protections really being realized for people if the information is still accessible through other means? I do want to just end with a few continued research questions that our Division of Racial Justice Statistics has going forward. Some of the things that we're still looking at. And again, I know that with all the testimony you've heard, it's possible that some of these have already been answered. We're doing our best to keep up. But some of the things that came up for us include, with the current data systems that the judiciary maintains, are we able to identify how many criminal history records are expunged or sealed on either a monthly or an annual basis? If we did have a process that was automated, and if we were to successfully implement that, are there indicators on whether or not these numbers may increase in the number of cases, I'm saying? What are the convictions that Vermont is seeing expunged or sealed most often? What are the current processing times for manual and for automatic expungement or sealing based on the processes that Vermont already has in place? Are there quality control and oversight mechanisms for the expungement and sealing orders that are issued for criminal justice and law enforcement agencies to ensure that expungements and sealings are actually being implemented? Do the criminal legal agencies that do part of this work have records identified with mistakes or other errata that need to be manually addressed? And if that's the case, are they being addressed, and how can those processes be made more efficient? And then another curiosity for us is, what does it cost to digitally store a record in Vermont? This is, I think, a rabbit hole that Laura had gone down in a previous role that she had at DOC, and also has maintained an interest in her current role. Because I think that, these days, so much is moving to the cloud, so much is moving to a digital storage system. And I think a lot of times we forget that there is a continued cost to that for the state. I think for us in our personal lives, you buy a computer or something, and it doesn't matter if I have 10 cat videos or 20 cat videos on that computer. I've bought it and it doesn't cost me anything extra to save all of my wonderful cat videos on that computer. But for the state, it's a little bit different. The data footprint that we have, the digital storage footprint that we have, costs us. It's more like a subscription model type of thing. And so what does it cost to digitally? What does a gigabyte cost? And if we think about retaining records for 10 years, 20 years or more, and the growing number of records that's going to involve, there has to be a consideration of the fiscal impact that's going to run us. And I think in some senses, there's also a risk management factor here that we may need to consider, right? The more entities to which we give access to these records, the more opportunity there is for breach or mishandling. If that's the case, that opens the state up to liability. That is a risk management issue. So the financial cost of retaining all of this information and the added liability for the expanded or continued access is also something that the state should be considering in terms of whether or not the return on this investment really is there. I've been talking so much. I'm going to pause and ask if the committee has questions, or if Laura, if I missed anything.
Yeah, I thank you for your testimony. I think, you may have heard me repeat this, like a broken record in past testimony, but one of my issues with expungement is the rather strange and somewhat dystopian idea of government destroying a record of punitive action that it's taken against one of its citizens, and then after it destroys the record, pretending like it never happened. And I mean, back in 2019, when I fully supported expungement, I was absolutely like, yes, 100% destroy everything, never happened, 100% clean slate. But in, over time, as I come to think about it, it makes me a little uneasy to allow government to erase its tracks after it's punished its people. So that's just my initial, I guess, philosophical thought on it. But the question that I have, I guess, pertains to, individuals who later on discover that they were wronged in some way. Perhaps they had ineffective defense counsel, the prosecutor mishandled the case, or perhaps the prosecutor was corrupt, or there was a police officer involved in the investigation who was later arrested for theft. And when that defendant years later sees, some officer on the digger or WCAX that they got arrested for this string of thefts, and they realize, oh, that officer was one that investigated something I was involved in years ago, and they realize they might potentially actually be a victim, and they want to go get their records because they want to rectify what happened to them. but those records are gone. That's a concern to me. And it would also be a challenge for whatever prosecutor is handling that and whatever defense attorney is representing that defendant in whatever future action happens. So, do you have any thoughts on that in general?
I do, yes. I do, and I also I'll say a little bit, and then I want to invite Laura to add. I think that for the second item that you mentioned about people perhaps realizing that they've been wrong, their cases have been mishandled, and wanting to be able to go back and get and have recourse for that. I think that one, we can do better during the period that so first, I think that because records first exist for a certain number of years before a person's even eligible to request a sealing or an expungement, then that begins our clock. So when we're thinking about the number of years that something might be available, there's already a startup time of several years before that clock even begins running. And then, so during that time and the time designated for how long we keep a record before it's destroyed or something like that, that is a critical period of time that we can do things like provide assistance to people so that if they do think that their cases have been mishandled, that they have recourse to deal with it while the record still exists before it's destroyed. We can have a program that maybe proactively looks at cases, some kind of review system, or that invites people or informs them of their rights to seek that kind of review early on, so that we don't have to wait for them to sort of stumble upon the realization 10 or 15 or 20 years down the line and then feel like, oops, I've missed my chance, right? So I think that maybe some proactive outreach, or at least better education, information, or support might be helpful to helping people resolve those earlier in that time frame. And then I think also the maintenance of that log by the judiciary may be helpful. I'll stop there because I think Laura would have done a better job of explaining that. Laura, do you want to jump in and add?
I don't think I would have done a better job, but thank you. For the record, my name is Laura Carter. I'm a data analyst in the Division of Racial Justice Statistics within the Office of Racial Equity. I really, so, and having watched a lot of this testimony, I'm really surprised, honestly, that the special index that the court maintains of the expunged and sealed records hasn't come up more as far as like expanding access to the parties that you have expanded access to during that 10-year access and use period, because the court is required for expunging and sealing in 7606 and 7607 to maintain a special index that on a high level captures what the conviction was when it took place. I believe it even has the docket number. I'd have to go back and look at the statute, but it's in this bill. So that's something I just want to highlight, because I think that there are still ways to access the information that we want as a government entity, and also do our due diligence to provide better access to justice for the citizens of Vermont. So that's one thing. I know that we've harped on this a bit. My Teams is going off. But that's why our office and division feel really strongly about having a management strategy in place once that 10-year period is over. If the committee decides to move forward with that 10-year period, we can't just have things exist in perpetuity. As Susanna mentioned, there is a digital cost for all of these things. Back in 2022, when it was a deep dive interest of mine, I believe we were paying like over $4 per gigabyte, which doesn't sound like a lot, but obviously that adds up. And if we're just maintaining these records forever, that also opens up us, I think, to risk and liability in other ways. I'm trying to think if there was anything else from your first question. But I just want to also say that H655 last year, that became Act 174 once it, passed and came through your committee. There was a mandated report, as Susanna mentioned earlier, and there hasn't been any discussion about that either. There were several recommendations within that I think could benefit the committee in approaching any amendments to the bill as it currently is, and that was submitted by Judge Zone.
And I guess I'm curious, I think there was mentioned that Vermont would be an outlier if we were to change this system. It's my understanding, though, that I don't know about Pennsylvania, but at least New York and Michigan, they both have a system that appears quite similar to what we're suggesting to move towards. And so I'm wondering about the outlier concept and what would make us different, because it feels currently like we're an outlier by being, as far as I'm aware, one of the only states that completely destroys records and then denies that they ever existed.
So I know Defender General Matt Valerio mentioned this in his testimony this week sometime about Marshall Paul having a lot of information in the study from Michigan, which Michigan, even though they're saying expungement, they do mean sealing. And I just want to again acknowledge a point that Susan made earlier, that what we have found in our research is that those terms are used interchangeably. There's really no solid definition. And again, people are kind of using them willy-nilly. So from our research, most of the country is doing sealing. However, there are expungement mechanisms that still exist, and Marshall Paul will definitely be able to expand on that because that was what a lot of his testimony was about last year in H655. I don't know if it would be useful, but I know his presentation is on the House Judiciary website from last session. But having him in as Defender General Valerio suggested and suggesting this now, he definitely would have those nuanced information for you. But I believe he did express this as well, that we would be an outlier. And I want to bring up something that Senator Wachowski said yesterday is, what about the dismissed cases? What about crimes that we've determined are no longer crimes? And then re-emphasizing the deferred sentencing aspect, where individuals are becoming part of this program with the expectation that their record will be completely deleted. So I think that there are still room for both things, that expungement definitely has a place at the table. And also, I just want to point back to that we have those special indexes from the court. Right now, those are not considered public. So like a member of the public would not be able to access them. I believe the judiciary or the judge has to give permission if someone does request it, but they are required by law to maintain that. So we would still have that high level information, even if the record was destroyed.
I believe that high level information is just for research purposes. I don't know, I might be mistaken, but I thought that's just what it's for. But I to see clarity on that.
Yeah, I mean, I'm not a lawyer, so you would definitely want to talk to your legislative counsel or someone from the judiciary. But in reading it, I'm on page 29 of the bill, and it starts on line 15, the special index. So it just kind of outlines it's the name of the person convicted of the offense, their date of birth, the docket number, and the offense that was subject to sealing. The related documents are supposed to be confidential or destroyed, depending on if it's expungement or sealing. And then there's like, you guys have added additional layer of access, but basically the chief superior judge can permit access only for research purposes. But I think what we're kind of suggesting here is that is a potential to be expanded as opposed to giving folks access to the actual sealed record itself.
Your point also about the deferred sentences, that's also well taken, and that's a decision point that we have to hash out later on, I believe. When it comes to dismissed cases and cases for which the offense is no longer a crime, I hear what you're saying, but on the other hand, my mind still goes to the place of, that person who believes that they were wronged in some way, either by law enforcement or the prosecutor or their own defense counsel. And years later wants to say, look at this, nonsense charge that was ended up getting dismissed. This is a thing that happened to me and I want to bring attention to it. And taking that information away from that person and then denying it ever existed it's just something I have a philosophical issue with. And so I guess that's not a question. It's just it's one of the things that's on my mind regarding this. We did also add, well, actually, I'll give you a chance to respond if you want to, and then should also see if the committee has any questions. I've been talking to you too long.
Yeah, I mean, I'm sorry.
So please go ahead.
I was just going to say, I mean, I think that I definitely understand that concern. It's one of the worst things is to consider that the system may have wronged a person and that the system might remove that person's ability to get recourse. So that's not something that's not an outcome that we're looking for. Again, I do think that if we make best use of that early period following the disposition of a case, when details are still fresh, when evidence is still, preservable, et cetera, we will have better success getting a person recourse if there was a failure in that case than if we let them, maybe stumble upon the conclusion that something went wrong further down the line. So I think that if we're talking about a retention policy for records and worried about a person not having recourse, then a good in-between measure would be provide robust support for people to address any issues that happen post-case, immediately post-case. And I also think that perhaps there could be, again, back to the sort of plain language and easily understandable language for people. There also could be, we can ensure that people understand, if you do become eligible for expungement or what have you, this is something that you may give up. This is something that may no longer be available to you in however many years. If you do choose to pursue expungement or if we do something automatic, then certain records will no longer exist. And at that point, you may not have a body of related documents to lean on if you later believe that something went wrong in your case. I think helping people understand that would also be really key, because then they can make an informed decision about whether, when, and how to act.
I want to just add to that too, something that we talked about earlier, something that came up earlier again. Chair Hashima, I believe you mentioned yesterday about just giving physical copies to the individuals. And I know Susanna brought this up earlier, but that was a recommendation that we had in a report that we published last year, as well as I know, and I can't think of the act number right now, but this was something I believe DCF brought up this morning about access to foster care records if you are the subject of the record. So including or developing some kind of process in place for that. So then the individual has the record that is of themselves and that the government has that higher level special index and understanding, in the case, thinking about dismissed cases, et cetera, et cetera. I think there are definitely ways that we can address it.
Any thoughts, questions out there? So I think I guess perhaps I was also looking at it too much with my defense attorney hat on, but I'm also wondering from the law enforcement perspective, in situations in which there is a cold case that is on the verge of being resolved 10, 20 years later. And, you know, the breadcrumbs lead to just this random obscure case in which there was a witness that's also connected to this cold case, and allowing law enforcement to access that old sealed case from 10 or 15, 10 or 20 years ago. Or, you know, an instance in which you have an extremely complex case, perhaps a case that's spanning multiple borders or, you know, through multiple states, multiple witnesses, persons of interest. And, you know, sometimes there can be evidence located in very unlikely places, such as a sealed record. Do you have any input or thoughts on law enforcement being able to access those very old records after going through a court process in which a judge would review their request and say yes or no?
I think that first we'd have to know the body of, or the list of offenses that would even be eligible, because some of those cold cases, we may still be able to access those things depending on what are the listed offenses we're talking about. So we're not talking about the full body of everything that would be gone theoretically. I also I had a little bit of a smile to myself when you said a cold case that's on the verge of being solved, because I mean, I am also hopeful that we can keep working on those cold cases and solve them, but I think we have to weigh the likelihood of being able to reopen and successfully resolve a cold case using this kind of information versus the benefit to the population as a whole for being able to, you know, give them the ability to start fresh following cases that the state has determined should be able to be put in a drawer. I think that benefit outweighs the possibility, the remote possibility, that we may be able to, you know, find our way through different sealed cases to some evidence from a case that's gone cold. So I think for me, if I'm looking at it from a researcher perspective, I would want to know what is the rate at which we're closing cold cases? What is the success rate? How often is that happening? And what is the likelihood that those cases, those kinds of cases, will be interconnected enough that those breadcrumbs do lead us to the answer? And I also recognize that for the individual who may be the subject of that cold case, you know, maybe for them, they don't see it as outweighing their interest, because to them, this is their life. I want to acknowledge that. But again, thinking about the impact that this has, the often disparate impact that this has on people who may be overrepresented in the justice system, I think that we're going to end up doing a lot more good for more vulnerable people if we consider whether, why, and how we need to maintain access to records of this nature.
Committee, any questions?
I want to just kind of piggyback off of that and go back to the records management piece of this. We can't make policy based on hypotheticals. And I just want to reiterate, which I know we've said before, to consider having the state archivist and chief records officer Tanya Marshall in to give some level setting on access to records broadly and having a management strategy in place and what that looks like in real life and how it impacts our work as state employees and also the citizens of the state that we are working for. Yeah.
Thank you. I mean, I feel like I have to respond by saying that, you know, my thoughts on this aren't based on hypotheticals. I mean, I've only been practicing for a year, but there have been a number of instances in which expunged records have prohibited me from presenting information that would show that certain police officers may have engaged in dishonest conduct. You may have heard about the Brady Giglio discussion we had and the inability for state attorneys to disclose that information and also deny that it ever existed, which has had an impact on more than one defendant that I'm aware of, at least just in my short time practicing. So they're not based on hypotheticals. They're based on situations that have happened here in our justice system quite recently.
I apologize. I guess I meant more kind of like this, all of a sudden we're going to crack this cold case after 45 years. I think I just want to echo what Director Davis said, that there are real implications. So thank you. I appreciate you explaining that further.
Committee, any questions? Further? No? Let's take, well, I guess actually we have Matt Russo. Actually, sorry, is there anything further from our witnesses?
That's all. Thanks very much for having us.
Great, thank you.
Thank you.
So we have Matt Russo at 11:30. Can you see if he could come in at 11? Thank you. Let's reconvene at 11.